Moving right along then, 2017-110, State of Arkansas versus Aaron Ashworth.
Your Honor, the only action on Mr. Ashworth today, in visiting with him, what does the court show his bond to be set at now?
Well, let me look it up. He's for trial in the week of January 29th, and this is his plea deadline date today. What I immediately find is there's a $5,000 bond. Wait a minute, I think that was posted. He's back in jail. He may not have one.
There's another.
Yeah, there's an alias warrant. Bond forfeiture hearing scheduled.
Back in October, the court said that he could, the original $5,000 would remain, but there would be a posting of another $10,000 cash or pro when it set, and that's when you set your picture.
I'm finding that October 19th, I set it at $15,000 cash or pro, condition on him not violating the law in any manner, not use or possession of any controlled substances or alcohol. Basically, it's conditioned upon that, $15,000.
Your Honor, I'm not asking for any change in the scheduling order. There has been a plea offer made that was gone over to Mr. Ashworth. Yesterday, at this point, he has not accepted that plea. He's not going to accept it today. I would like, Your Honor, to ask that his bond be set at the original amount of $5,000 or modified to that amount. His mother, and if we need to verify this, Loretta Anderson, according to what he told me yesterday, is in intensive care at the hospital with COPD and emphysema. I would submit to the court that that's certainly a change that I would ask the state and the court consider in setting a bond that he could possibly make.
What says the state?
Your Honor, our first concern would be that is that some confirmation of that be provided in some way. Unfortunately, a lot of times when people are in difficult circumstances, the things they reflect to the court are the circumstances that, or even the severity. I'm not saying that, and I'm not trying to be glib about his mother's condition, but just he's got some pretty, serious charges. Any reduction, mainly we would want to see contingent upon some sort of documentation of what it is that his mother's condition is.
Your Honor, apparently his mother has called our office, and Amy says that we have a number that we can call. So we can call her and see if we can get some sort of written documentation. If not, then maybe during the break, Mr. Brown and I can talk to her and he can confirm that she is in the hospital.
While I'm very sympathetic with the situation, the bond was up because he didn't appear in court. Which is the essence of why we have bonds is to assure people's appearance in court. He was out on the lower bond, and that wasn't sufficient to guarantee his appearance in court. I'm uncertain, mainly because I've had the experience of people giving very good reasons, like the mother's illness, to get out on bond or even be OR'd under certain circumstances. And I've made the mistake of taking them as sincere in that and then have them run off. that the fact that their relative was in really poor health made no difference. Getting out of jail was all they were shooting for. So I hate to be cynical in that regard, but at this point, I'm going to leave the bond where it is. I will entertain a renewal of the motion based on first, as the state says, a confirmation of the actual condition, and I would want to consider other conditions on that bond if we were going to reduce it in any way. But at this time, the bond will remain at $15,000. That's the court's ruling on that.
Aaron, we will call your mother at the break, okay?
And the case is set for trial during the week of January 29th at this point.
We're not asking for any changes on that. Aaron,
Yes, sir.
You may be excused, sir.
we will call your mother at the break, okay?
All right, thank you.
Just
2017-176. I have this case down for, this is State of Arkansas, State of Arkansas versus Justin Pennell.
Judge, we have in our file a similar order where the court reflects that on 19th he did not appear. Also, that we've been provided documentation from the Christian County Sheriff's Office out of Missouri that Mr. Pennell was incarcerated on October 19th in regard to two matters there that needed to be disposed of.
Somehow we managed to enter an order, and the court, I'm sure the court signed it for a revocation hearing. Just a mistake on my part. So we'll go to, we need to get him rescheduled. The first thing we need to do is get him rescheduled for trial. This is an old, well, it's not, it's a somewhat old case. I'm going to set it for trial the week of, huh? Yes, because it's excluded because he failed to appear, and we had to cancel a jury trial. So I'm going to consider this. I'm going to get it reset for trial from today's date till the week of January 29th.
Our defense has no objection to that being an excludable period to the defense.
So he's now set for that. He'll reappear on January 18th. He's ordered to appear on January 18th for pretrial and/or a plea deadline on that day.
I think that...
Now, do we want to discuss bond further?
Yes, Judge, I think this is what Mr. Brown and I have agreed upon, is that his bond, he's already posted bond, and assuming that his bondsman is still good with staying on his bond, that would take care of that. What the state, I believe, wants in lieu of another additional bond is the extradition cost of having to go to Missouri and pick him up.
That's correct, Your Honor. Our office has that there was $155.05 in mileage, and then also the per diem cost for the deputy to go and get Mr. Pennell and bring him back. And so we would like that added as part of his bond.
The idea would be to reinstate the previous bond.
Yes, Judge.
Yes, Your Honor, with the addition of the costs to the sheriff's office and having to transport him back.
Is the previous bondsman willing to stay on his bond?
I don't know, Your Honor.
Justin,
Yes, Your Honor.
who is your bondsman?
Ron?
All right, I have,
Mark, I'll text Ron.
okay, we'll find that out, Judge.
I know that I'm still in good standing with him on my bond.
All right, we're going to find that out, okay?
We're going to get him to verify that, and I want to,
Your Honor,
yes?
I got OR'd from Christian County Jail and on my charges up there, and I had taken up drug court, and I was supposed to get assessed for that, and then of course I had a warrant down here for to see you, to appear in front of you. I've been here for 11 days now. I was wondering if I can get time served on that, on the $150 plus per diem that I owed for expediting. I mean, I signed the expedition papers and everything willingly. You guys can get me, knowing that I missed my court date. I had a letter of incarceration printed out and everything, knowing that I had every intention on being here for court. I'm the only provider for my household, and since I've been locked up, I have no money. I'm asking if maybe I could if you could OR me or something, and I'll make it to the next court date. I can give you my word on that.
Your Honor, we're being told when we check with the bondsman that the bondsman is not willing to stay on the bond at this time.
Well, at this point, we're dealing, if the drug court was one in Arkansas, the court would have a little bit different attitude, but because it's in the state of Missouri, the court is at this point, and the bondsman's unwilling to stay on the bond, at this point, the court's going to, the bond will be, what was the bond?
Your Honor, the bond started at 15, and the court already reduced it to 5 at one point, and part of that was that Mr. Pennell was not to leave Baxter County, and at this point, the state feels like that's.
I was extradited to Christian County, Your Honor. Christian County came and got me. They had a hold on me here. And I owe the bondsman $200 if I understand that. My wife was the one that took care of it. And if I understand, it's like $200, $250 that I owe him. I can come up with, like, at the most $150 if that's what it would take to get me out of jail today, so I can go back and get back in contact with my probation officer up there and get assessed for drug court. And I don't have any revocation pending on me anymore up there, so I can get a state pass down here. The judge up there is aware of my charges down here, and I mean, I have them. I'm in good standing with them now. I don't have revocation or anything pending on me up there. If I could just get released from this jail and get back up there before I get another warrant issued for my arrest up there and a hold here, I can, make some payments, or I just keep.
Your Honor, can I suggest a resolution?
All right.
That his bond be reinstated at $5,000. He can talk to his bondsman, I can talk to his bondsman. We'll see if there is a way to work that bond out. That also, in addition to that the extradition cost that Mr. Brown has set out, that be paid before he is released. So, in essence, if he is good with his bondsman, then and he can pay the $155, then he would be released if that's acceptable to the court.
Court's going to go along with that. The apparently it's going to require a new $5,000 bond. The previous bondsman is, I don't have the authority to reinstate a bond if the bondsman is not willing to remain on that. So it'll require the posting of a new bond, and as an additional requirement for the posting of the bond, the court's going to direct the defendant will have to pay to the Baxter County Sheriff's Office the sum, whatever the sum was, the specific amount to cover the cost of having to extradite him or go up and get him back. It was under $200 is what I think I heard. But so there'll have to be a cash posting in that amount, and then a bond from a bondsman or a separate cash posting on the $5,000 in order for the defendant to be released. Once he's released on bond, he'll be obligated to appear on January 18th in this court and be available for trial on the week of January 29th. That'll be the bonding arrangement that the court will authorize. Now, I'm not going to put any, knowing that you have obligations in the state of Missouri, I'm not going to put any restrictions on your staying in the state. But I'm going to tell you that if we have to go through the process of getting you back down here another time, there won't be any bond to get you out of jail, period. I mean, we're going to hold you until we can dispose of your case. We've already had to cancel one whole jury session because you got, I don't know what the circumstances were, but you got yourself in trouble in Missouri and weren't available to go to trial. So, we're going to move this case on the docket. It's going to move in January, one way or another, and you need to be available and down here. And if you're not, and we have to come get you again, the next time there will be no bond for your release. Period. We're going to get this case over with. So just understand that it's your responsibility to take care of your problems in Missouri, so that they don't cause us to have to cancel another jury session.
Yes, sir.
That'll be the order of the court.
Your Honor, before he's excused, and since I will not be able to see him today, if I understand it correctly, if his bondsman that he had previously, if he's willing to stay on his bond, that would satisfy the $5,000 requirement.
As long as he posts a $5,000 bond. If he, apparently, the bondsman has communicated with the state, with Ruth over here, that he's not willing to stay on the bond. So all I'm saying is the status of his bond, to be released from jail here, he has to post a $5,000 bond and post cash, a cash payment of the amount, whatever.
It'd be $155.05, Your Honor.
$155.05 with the sheriff's office. That money will be subject to being paid to the sheriff's office for the cost of the, or to the county for the cost of having to go get him the last time. That's all. That's what's required to bond him out. And I really don't care what form that bond, in other words, whether the bondsman, the old bondsman renews it, or whether a new bondsman comes in and puts up a $5,000 bond. So those are arrangements he'll have to make. But that's the status of this case.
Thank you, Your Honor.
He's set for reappearance on January 18th and trial during the week of January 29th. All right, you may be excused.
Thank you, Your Honor.
And if you get out, you need to get Mr. Pennell.
Yes, sir.
If you get out, you also need to get in touch with and stay in touch with your attorney. I'm ordering you to do that.
Yes, Your Honor.
He can't prepare a case or prepare a plea for you if you aren't in good communication with him. So and that's your obligation, not his, to track you down. All right?
Yes, sir.
All right. You may be excused. All right, so then we're on to 2017-220, State of Arkansas versus Blaze Forrester. We also have 2017-241.
Your Honor, Mr. Forrester, I think your file will reflect that the evaluation that the state has done has come back at my request. Your Honor, after reading that evaluation, I have serious concerns. I have voiced those concerns to Mr. Forrester. His mother is also here. I believe it's in his best interest that an evaluation be conducted by the Public Defender's Office at the Public Defender's expense, and I have expressed that to Mr. Forrester. and also to his mother.
All right, let's see where we are. Both cases are set on the court's docket for the week of January 8th, with this being the plea deadline date. But the defense is moving for an additional evaluation at their at defense expense.
That is our motion, Your Honor.
I'm going to continue the court's going to grant the motion to continue as an excluded period. What's the trial week in March? Is it March 26th? I want to give him as much time to get that done as possible. So I'm going to, at defense request, I'm continuing the trial to the week of March 26th as an excluded period. I'm going to set him for reappearance for this court on January 18th to check on the status of the defense evaluation. If we can get it done sooner, and if necessary, set a hearing on if there's conflicting evaluations, we'll set a hearing to get the matter set as quickly as possible. But that's, so the January 8th trial date is canceled in favor of, the case is continued to trial to the week of March 26th as an excluded period, and his next reappearance in court will be January 18th. 2017-276, State of Arkansas versus Stephen Brown.
And we met with Mr. Brown yesterday. There's no action to take in this case today.
His case, this is the reappearance check status of the case. Cases, I understand, is reported discoveries proceeding, pleas are being made. Case is down for next appearance will be January 25th, and that appearance is for pre-trial. You may be excused, sir.
Thank you, sir.